Today we're pleased and privileged to bring together two courageous and prominent Russian human rights attorneys, Sergey Golubok and Anton Burkov, who will be sharing with you their experiences as frontline human rights advocates in the Russian Federation. They work for a common cause through approaches and methodologies that differ but are complementary. We will hear first from Sergey on the topic of rule of law in Russia, contemporary challenges. We will then hear from Anton about when candidates are the election monitors using strategic litigation to advance democracy in Russia. When both have finished speaking, we will open the floor to the audience for questions, comments, and lively discussion. First, we're going to turn to Sergey. Sergey Golubok lives and practices law in the city of St. Petersburg in the Russian Federation. He graduated from the St. Petersburg State University Law School. 2 years later, he received a Master of Laws degree in International Human Rights Law from the University of Essex in the United Kingdom. He then spent 3 years serving with the Registry of the European Court of Human Rights in Strasbourg, France, and one as a legal program officer with Redress Trust in London, before returning to St. Petersburg to take his PhD in International and European Law from the St. Petersburg State University Law School in 2011. He is presently an attorney at law with the firm Semenyako, Grib Partners. I'm also pleased to recognize and welcome the head of this firm, Nina Bohr, who has accompanied Sergey on his trip to the US. Over the past several years, Sergey has been involved in aspects of many high-profile human rights cases in Russia, including the LGBT case and the case of the Russian feminist punk rock protest group Pussy Riot. In the fall, he defended one of the Greenpeace volunteers arrested at gunpoint in international waters and charged with piracy for staging a nonviolent environmental protest. Beyond his role as defense counsel in this case, he served as a general consultant on international law to all parties involved in the criminal prosecution of the Greenpeace activists. All these credentials make it very clear that he is qualified to speak to us today on the challenges facing human rights activists in Russia today. But on a personal note, I have to add that it is not just his credentials that qualify him, but the unfailingly humane support that he offers to defendants in need, and the honorable, fierce, selfless, and fearless way he advocates for them. I can attest to these qualities on a very personal level, as one of his lowest profile defendants has been my youngest son, who had the misfortune of falling afoul of the St. Petersburg legal establishment last summer. At any rate, I am honored to present Sergey Golubok to you today.
I'm very happy to speak here today, and I'm also happy that the screens are down. So excellent skyline and view of Boston does not compete with me. But I would like to try to use my time to paint another skyline of rather broad topic of rule of law in Russia and contemporary challenges that this nascent democracy faces. Rule of law is one of those terms that everyone perhaps has some understanding of, but which does not necessarily have very defined conceptual understanding which is generally recognized. In Russia, another term is used, which is in Russian language правовое государство, which is a literal translation of German Staatsrecht. That is state governed by law rather than rule of law. That highlights the special role of state rather than law itself. However, recently there were a number of studies trying to highlight different elements of rule of law. Perhaps first writer that has introduced this concept into English legal terminology was Dicey, the famous British legal specialist in theory of law in the 19th century. And recently in UK, late Tom Bingham, Lord Chief Justice of UK, wrote very powerfully in his book Rule of Law about the elements of this concept. In 2006, the United Nations Secretary General produced a report on the elements of the concept of rule of law. There is a definition given in this report that I will use for the purposes of this talk. That rule of law is a principle of governance in which all persons, including the state itself, are accountable to laws that are publicly promulgated, equally enforced, and independently adjudicated, and which are consistent with international human rights norms and principles. So I would say there are four most important elements here. Laws that are publicly promulgated, laws that are equally enforced, laws that are independently adjudicated, and laws that themselves comply with international standards. First of all, international human rights standards. I would like to go into those four elements and suggest some case studies on what are the challenges in Russia. First of all is an element of publicly promulgated laws. That means that laws are not just adopted by the parliament and are made available to everyone. That means also that public participates in the discussion that leads to the adoption of laws, in a way that public feels itself part of this process. Indeed, Professor Amartya Sen, in his book, very powerful, I would say, book, Idea of Justice, wrote that democracy is first of all about public participation and deliberative process. In Russia, recently, Parliament has been given a label of crazy printer because laws are promulgated as half-baked cakes, when even those who have adopted them don't care really to read them properly. Exactly because of the lack of meaningful public participation in the procedure. It is not unheard of to have bill introduced, and law adopted just 2 weeks thereafter, just because someone wants this law in place right now and right here. The law on how to include Crimea into Russia is now in pipeline. Probably next week we'll bring it into the books. This process is not only unfair, it's also very ineffective. It gives birth to laws that are not very well thought through. I will give you an example of recent very controversial legislation on labeling certain non-commercial, non-governmental organizations as foreign agents. In its pursuit to silence vocal critics of governmental politics and governmental stances in various areas of life, it was decided by someone to introduce the label with stigma of foreign agent and attach it to any non-governmental organization that receives foreign funding, irrespective of the amount of foreign funding. Foreign funding includes donation of $1 from Ukrainian national, for example, who is even resident in Russia. And if this non-governmental organization tries to influence governmental policies. Another problem here that in Russian language policy and politics are semantically the same word. And of course it's very hard to distinguish between those who are vying for power and those who just want to try to change legislation on town planning, for example, because it will still be an attempt to influence politics, understood as policy, in effect. The case is now pending before the Constitutional Court of Russia, and Anton will speak about what the Constitutional Court is doing. And a number of NGOs try to invalidate these laws as unconstitutional. But interesting thing with this law is that this law does not cover foreign organizations that are active in Russia. It covers only Russian organizations that receive foreign funding. There were very interesting studies comparing this piece of legislation with American FARA, Foreign Agents Registration Act, because the authorities try to perceive Russian legislation as the reminiscent of the American one. And the studies showed very, very eloquently that there is nothing in common between these two laws, because American legislation concerned commercial transactions, when Russian legislation touches upon non-commercial organizations, etc., etc., etc. But the most important point is lacking in Russian legislation because it does not cover real foreign organizations. When one tries to go and have a look at the records of deliberations in the parliament, it is evident that the members of the parliament actually forgot about foreign organizations and forgot to include them into the definition. They thought it would be self-evident that foreign organization is a foreign agent, but actually this definition does not cover real foreign organizations, because there is no real deliberation in the process, because the parliament does not act as it should act, having taken into account different views, having heard to the critics, having heard to the opponents of the proposed legislation, etc. But quality of legislation, I would say, is not the most important issue. The practice of its implementation, the practice of its enforcement, is perhaps a more important challenge. Back to the UN definition, in the rule of law, laws should be equally enforced. It's evident that arbitrariness in application of laws leads not only to chaos and unpredictability in relations within the society, but also to the lack of respect to the authorities and eventually loss of their legitimacy. I would like to look at the issue of pretrial detention or detention on remand. That is, I think, interesting case study of how lack of equality in enforcement of the legislation undermines one of the most crucial elements of the legal system of every country, criminal justice. The idea of pretrial detention or detention on remand is to ensure that the defendant does not flee when the matter is being investigated, does not try to obstruct with the investigation, and does not commit other offenses. So the whole idea, based on the presumption of innocence, that the person should not be arbitrarily detained pending investigation unless there is evidence showing that the person can commit one of the deeds that I've enumerated. Influence the witnesses, try to flee, or commit other offenses. Normally, bail should be granted, or other measures should be taken to ensure the presence of the defendant at trial. For example, through house arrest or some other measures. Bail is definitely one of the most universally accepted. However, not only in Russia, in other post-Soviet jurisdictions, bail is understood as privilege that is granted to the defendant only when he or she is willing to cooperate. So basically, detention on remand is used as a preliminary punishment in order to make the person who is not very eager to cooperate with the investigation to think twice. And if it's not enough, the detention on remand can be extended up to 18 months in order to allow the person to think thrice and more if necessary. Interesting example of how this materialized was the criminal prosecution of Greenpeace, members who have been captured by the Russian authorities when they tried to stage peaceful protests near Prerozlovne oil rig in the Pechor Sea. They were initially charged with piracy. Under Russian law, piracy is understood as a violent attack with a personal gain against a vessel, a sea-going or river vessel, without even thinking about personal gain in this protest or about thinking about violent element of the situation. Problem was that Prirazlomne was not and is not a vessel. It's a stationary rig. So to charge someone with piracy, even for violent attack against Prirazlomne, is something like charging someone with murder when the corpse of dog or cat is found. There is no object of this crime. And of course, you need to have reasonable suspicion established to justify detention on remand. And in Greenpeace case, that was argued on behalf of the defendants from the outset that Prirazlomne is not a vessel, hence piracy charge lacks conditio sine qua non element of it. Nevertheless, all 30 requests of the investigators for a detention pending investigation for 2 months were granted by Russian courts. And 1 month into the investigation, investigators, under of course public pressure, suddenly realized piracy could not have been committed because Prirazlomne was not a vessel. They made this finding, but they kept it secret. They did not communicate it to anyone. And it became available to the defense only 2 months into the investigation and into the detention, when the investigators asked for extension of detention on remand for another 3 months. At that moment of time, they said, look, now we think it's not a piracy. Now it's perhaps hooliganism. That's another matter whether it's hooliganism or not. No one knows that because the matter was discontinued because of the amnesty. Very hastily adopted, I should say. Back to the first point, amnesty adopted just within a week. Of course, it's also a decision of the parliament. So, but the point is that in this situation, authorities decided to use detention on remand in order to try to influence, to exert pressure upon people in detention to cooperate with the investigation and to give testimony. They did not give testimony. Following 2 months and public outcry, the investigation just backstepped. However, in other cases, for example, in notorious prosecution of former Minister of Defense who was accused of corruption, high-level corruption, investigators, former Minister of Defense, who was of course very well linked and could have prevented prosecution from going on, the investigators even did not ask the court for detention on remand because cooperation with them was provided by the defense and there was no need to exert additional pressure. So lack of equal enforcement of legislation is definitely linked with the third element, and in my understanding the most crucial element of the rule of law structure that is indispensable for the functioning, and that is independent judiciary. I would like to draw attention to the Commissioner for Human Rights of the Council of Europe report from the Commissioner of the Council of Europe for Human Rights, published in November 2013, and which is specifically dealing with the state of judiciary in Russia. His conclusions are very, I would say, unequivocal. He writes, "System is unfair and should change. Judges are not shielded from undue pressure, including from within the judiciary." And I think it's important explanation of the origins of the lack of independence of the judiciary. The vertical hierarchy within the judiciary. When the judge is very much supposed to receive instructions from the president of the court, who in his or her turn receives instructions from the president of the Court of Appeals. Something that is not really accepted in many jurisdictions when president of the court is just administrative officer without authority to give orders to the judges in his or her court. Here the system is different, and the underlying issue and the underlying trace of this system is that hierarchy of judiciary is akin to hierarchy of any other state agencies. Judiciary is not understood as different from, let's say, law enforcement or from tax authorities. It should be organized as hierarchically subordinated system with the lower judges reporting to the higher judges. In this situation, definitely, the judge has no space to be independent, and the judge is no different from police officer. Ultimately, it of course leads to the influence of the higher executive upon the higher judges. Career path of judges is another interesting example. In many countries, like for example, there is a big debate between United Kingdom and United States on whether political appointments to judgeships are appropriate. And they like to criticize the United States and the United Kingdom, saying, how can you really think about rule of law when it's a political issue to appoint a justice of the Supreme Court? However, it's understood that judges are recruited from other parts of legal profession. To the Supreme Court, they are very often professors of law or serving judges, but nevertheless judges with experience of lawyering or teaching. In Russia, as in many other jurisdictions, unfortunately in that part of the world, legal profession is not as developed to suggest other career paths to become judges. So in a nutshell, judges are former clerks working in the registries of the respective courts, and that gives them professional background of following the orders. They have used to follow the orders when they used to be clerks, and they still follow the orders when they're judges. So good, so far so good. Three elements, all with substantial problems. However, of course, all those three elements, publicly promulgated and accepted laws, which are equally enforced and independently adjudicated, those are all elements that are about form, not about substance. Of course, normally these procedures should lead to maybe various types of substantial laws that are substantially fair. But I think interesting element here is compliance of those laws with international standards. First of all, with international human rights standards. And for Russia, it's first of all Council of Europe standards, and standards that flow from the judgments of the European Court of Human Rights and from the decisions of other Council of Europe bodies. And here formally one can say things have changed, because since mid-90s Russia has become a member of the Council of Europe, and there are now thousands of judgments of the European Court of Human Rights that have been pronounced in cases against Russia and that have to be complied with. Problem here is that European Court of Human Rights is not a court of appeal. European Court of Human Rights can highlight the problem by saying that in this case the European Convention on Human Rights have been violated. However, it's then up to the authorities to implement this judgment insofar as individual and general measures are concerned. Individual measures meaning, first of all, retrial or other actions to remedy the situation of the successful applicant in Strasbourg. General measures is the changes in administrative practices or case law or legislation to prevent similar violations from occurring in the future. Here, situation is much more problematic. International law is without mechanisms that would force individual states to comply with pronouncements of international adjudicatory bodies when the states are not inclined to do that. Ultimately, it's up to the individual state really to comply or not. And general measures and even individual measures require actions on the part of the parliament and of the judiciary. whether the problems that I have referred to just several minutes ago. Unfortunately, many pronouncements of the European Court of Human Rights don't lead to the change in the situation. And that is also backfiring against the European Court of Human Rights itself, which receives more and more clone cases that emphasize the same issue that has already been decided upon in the previous judgment or judgments from the European Court of Human Rights. To try to wrap up this, what is the source of many issues that I've described is the lack of institutions that could have been built anew, but were not built. In some areas, those institutions were built in some technical areas. For example, there were no tax authorities in the Soviet Union because there was no private enterprises. A new tax authority was built. That was technically important for the state to function, of course, to gather taxes. However, in terms of parliament, in terms of especially functioning of the judiciary, in worst case scenario, Soviet institutions were left intact. In better scenarios, there were minor changes in them that did not change the overall picture. There were nice additions into the system, like the Constitutional Court of Russia. However, like the European Court of Human Rights, the Constitutional Court is not empowered to quash the individual judgment, the judgment in the individual case. It is only entitled to find whether laws are in compliance with the Constitution. And even if it says that they are not in compliance with the Constitution, it's then again upon the Parliament to amend, upon the crazy printer to amend. So that makes this institution important in terms of pronouncements it makes, but not very relevant in terms of actual changes into the situation. And of course, this institution building is definitely the task of society within Russia. Only when society generally recognizes the need in this institution building, it will be possible to make first steps on this path. I understand it's a slightly grim picture, and one would say, what's the outcome? I would say the demand for changes is growing, and recent events in Ukraine showed this demand can change the situation rather promptly. When no one really expects these dynamics. But I would also say before that, one should rely upon miracles, because miracles do happen. Even in this situation, sometimes one can find a publicly promulgated, more or less reasonable law that can be equally enforced. And within the judiciary, it's more or less possible to find one or two magistrates who will be able to have it enforced in particular case. Anton is now working with Kennan Center in DC as Galina Starovoitova Fellow. Galina Starovoitova was politician who became a victim of political assassination in the 90s in St. Petersburg. She was a member of the Russian parliament of Duma who really made a lot to try to build institutions that are unfortunately still absent. And monument to Galina Starovoitova is located in the small garden that Emily and Sam are very well aware of, just next to the building of Smolinsky District Court, when one miracle happened in one separate case. So I just think that is a right moment to pause, that miracles do happen, and miracles first of all happen because of individuals. Individuals like Galina Starovoitova, whose monument is still in St. Petersburg, and that raises hopes for changes in the future. Thank you, and I will be happy to respond to questions if they arise.
And this afternoon, it's my great pleasure to introduce our second speaker, Anton Burkov. Anton is a human rights lawyer from Russia with no less than 4 different law degrees, including a PhD in law from the University of Cambridge in the UK. Over the past 16 years, he's spent time working as a lawyer with a human rights organization in Russia called Sutyajnik, and that organization's name basically means a litigious person, someone who likes to go to court, and in this case, for good reason. While working there, Anton has prepared many cases for Russian citizens trying to uphold their rights at the European Court of Human Rights when the Russian courts have failed to do so. And he has also successfully argued cases in front of Russia's Supreme Court and Russia's Constitutional Court, some of which we're going to hear about today. He's also an active scholar who's written several books about the ways in which the European Convention on Human Rights is and is not implemented in the Russian court system, despite the fact that Russia has signed that Human Rights Convention. And he's published more than 20 articles in major Russian and English language law journals. Anton is also the chair of the European and Comparative Law Department at the University of Humanities in Yekaterinburg, where he's teaching a new generation of Russian students about the importance of using the courts to uphold the rule of law. He's also held a number of prestigious fellowships, including the one that Sergei just mentioned, the Starovoitova Human Rights Fellowship at the Kennan Institute in Washington, where he'll be in residence for the next 6 months. So with this wealth of talent and experience, Anton Burkov has come to us to share his thoughts on ways to use the courts to try to promote democracy in a country that sadly seems to have become increasingly non-democratic over the last decade. So let us warmly welcome him to UMass Boston.
Well, hello everybody. Thank you for invitation to be here today to share with you about what we do in Russia, what we do in courts, what we do, how we help general people to defend their rights in the court, and that's why they call it Sutyajnik. I will just say some words about the organization that I have been working with since I was a student, since I was a law clinic student. As Valerie already mentioned, basically the name of this organization, Sutyajnik, can be translated as a litigator. It has 2 meanings. The first one is a person, it's an old Russian word, meaning that a person who is going to court to defend his or her rights. And the second meaning is usually it's a contemporary, and it's used mostly by the government officials who dislike us for our activity. And it's a mental illness term. It's a person who is thinking that everybody is against him, her, and that's why this person is looking for a remedy in the courts. So, what Sutyajnik is doing for almost 20 years, in September this year there will be 20 years of this organization. Sutyajnik does litigation in national courts and before the European Court of Human Rights if all the attempts within the national courts have failed, and through teaching human rights, through workshops, through summer schools, winter schools, and also our members are teaching at universities. And we also distribute a message about human rights. We organize a special news agency, Sutyajnik Press, which spread the message about the cases we are litigating, the trainings we are conducting, and about general situation in legal world in Russia. And today I'm going to speak about the technique that we use, strategic litigation, or as I think in the US it's called cause litigation. And in particular, we use this technique in many different ways, in many different cases, in many different areas. And one of this area is democracy, elections, particularly election campaigns. Before, I can mention some of the cases that Sutyajnik has handled before. For example, in 1999, we've won our first case before the Russian Constitutional Court, where we challenged one provision of the Code of Administrative Offenses, where we challenged this provision which did not allow to bring an appeal of a person who was accused of a minor offense, minor crime, if you can say. So due to this case, the Russian new Code of Administrative Offenses was equipped with this appeal system. Now everybody can appeal administrative offenses. So what we started to do with strategic litigation in 2000, when we run a number of two drop-in reception offices, consultation offices in a small town of Serov. It's north from Yekaterinburg, the capital of the Urals region. After a year of doing so, those who approached us in the consultation offices advanced our lawyers to run for local offices, for city council, for a mayor of the city, of the town. And we thought it was very you have to respect what people ask you to do, and it's very important. It's not litigating cases. We thought we should try to do this, but not only from the point of view of actually winning the elections and running an office. We thought we might use it as a strategy to actually observe, monitor what's happening during the elections. It's easier to observe elections when you are a voter. You come to the voting pool, you drop your ballot, you kind of can try to see what's going on, how it's being counted maybe, but it's much more difficult to see how the process is going from this position of the candidate. And so we decided to do so and run for a number of offices. And we faced a number of small and major violations of the right to be elected. And one of it I will mention today. We call it the unpublished financial regulation case. The point of this case was that a number of candidates, including us, faced with the problem that local election commissions, which supervise the order of running election campaign, started to prosecute some candidates for not following a financial regulation issued by the regional election commission. And this financial regulation basically established how you spend the money on election campaign and how you report to the authorities. And we realized that later that this regulation was basically not published. That's why candidates could not really follow the regulations. So we decided to challenge this regulation in the court of law, initially at the regional level court, and then before the Supreme Court. And our major argument was this regulation was unpublished. How come anybody can actually follow this regulation? Although we lost this case, and actually it's interesting how we lost this case, because the Supreme Court, hearing the appeal 4 months later after the elections, after the date of the election, decided to accept an evidence of publication of this regulation, which was made 2 weeks before the hearing. So it means 4 months after the election, 4 months after anybody can actually follow the regulation. It was quite a big disappointment in the Supreme Court, as before it was kind of a court which can actually give a change, make a change. But what we were able to achieve with this case is when we started to litigate the case, we started to use mass media to spread the message that what's going on and that selected candidates are being prosecuted because of the unpublished, not following the unpublished act. This case actually stopped the prosecution of the candidates. And further future financial regulations about the elections are actually published now. Later on, 2 or 3 years after, we moved further in our strategic monitoring of election process, and this time of pre-election process. With the help of our labor union colleagues from the Urals, we established a regional branch of the All-Russian Labor Party in 2003. And right after the registration and before the first elections, the Minister of Justice, is the regional branch of the ministry, requested the party to submit applications of all the members of the regional branch of the party. And of course, we refused to submit such applications on the grounds that those applications contained members' personal information, address, telephone numbers, sometimes emails, well, and first of all, the names. And we also argued that this request interferes with the inner activity of the party, and the Minister of Justice has no authority to do so, and this interference qualifies for violation of the right to freedom of association, a violation of the Article 11 of the European Convention of Human Rights. And we used this argument before the district court and then before the regional court. Unfortunately, we lost these cases. And the court said that we have to submit those applications. And as a last resort, we went to the European Court of Human Rights. So far, 10 years has passed. So far, the European Court of Human Rights is still looking into this case. It started the procedure of communicating the case to the Russian government. The Russian government already responded. We're still waiting for the judgment on the merits. Despite the fact that it was already 10 years since what happened, and the outcome of the case, the judgment of the European Court, will probably not help the party, but it will set up a very important precedent for the future to follow, including for the non-governmental organizations, not parties, but non-governmental organizations as ours, to not to disclose information about the parties, the members of the non-governmental organizations. Just recently, before me going to Washington DC for this fellowship, our NGO received a request from the Minister of Justice to submit the list of members of the organization. So perhaps, again, we will refuse, and hopefully this year the European Court of Human Rights will deliver the judgment, and we'll be able to use it in our defense. And you can see the link. You can access all the materials on this case and all the cases that I referred today. That's actually a part of our strategy. We try to publish online all the cases, all the case materials that we are litigating, so other people can access them and can see that there is a possibly remedy in their cases. But what's interesting about this case, I just recently saw in this book by Peter Irons, published in the 90s, The Courage of Their Convictions. You probably know about this author, and I was very much pleased to read this book. And I found similarities with what's happening in the US in the 60s and what's happening right now in Russia in this very, very particular case. The head of the Little Rock office of the National Association for Advancement of Colored People, Daisy Bates, here is on the picture, in 1957, I believe, refused to provide a list of members of her local branch of the organization. And this request, she received this request from the prosecutor because of her active role in implementing the judgment of Brown versus Board of Education, actually to help black students to study in school, in Central High School. And Daisy Bates refused, and she was charged for this $100. But she won this case before the US Supreme Court. And later on, the regional court ruled that non-governmental organization has is not obliged to provide such a list of members. So, more recent examples of a case where we supervised, monitored elections from the standpoint of the voters. And actually it was the election of 2012, election to the State Duma, where monitors recorded a lot of fraud in counting the votes. And there were a lot of cases going to district courts where monitors or just voters, regular voters, brought a case against election commission, local election commissions, where they argued that the counting was, there was a fraud during the process of counting of the votes. And all the courts, all the election commissions, all the courts, all the prosecutors which were involved in these cases interpret the Civil Procedure Code, particular provisions of the Civil Procedure Code and relevant provisions of the federal law on voting rights, that regular voters have no standing to bring a case to district courts because they only have a right until they drop the ballot into the box. What happened after, it's not their business. What happened after is the business of political parties which submit candidates to run for the State Duma. It's a very interesting interpretation which provides the biggest ever threat to democracy in Russia, because it's like this saying, you come to vote and then no matter how we count the votes, it's none of your business. So a number of activists, voters from different regions, including Voronezh and St. Petersburg, brought this interpretation of the law, not the law itself, before the Constitutional Court of Russia, which had a hearing in March 2013, and in April 2013 it delivered the judgment, actually returning the standing to regular voters to bring in case if they're not happy about the counting, if they're not happy about the outcome of the elections. Unfortunately, the Constitutional Court did not support that the monitors, who especially there to supervise after the elections, that they also have a standing, and also the members of the local election commissions, who they also do not have a standing from the point of view of the Constitutional Court. But still, I believe it's a very important case, although it's kind of obvious that how come a voter has no standing. The recent elections, where we participated again as candidates to a mayor of Yekaterinburg, the capital of the Urals region in Russia. And again, our main goal was not to win. It's like an Olympic slogan. We are there not to win, but to participate. to monitor the elections and to find out what are the violations. And we faced with one major violation there. When you run for an office, there are sort of two stages to become a candidate, a real candidate who can go and run for an office. First, the party advances a candidate to be a candidate for a particular office, and then you, as a candidate, collect some documents, provide it to the election commission, and the election commission say, yes, you're qualified. You go to the people, collect your votes, advocate yourself, your program. But we realized that some candidates are not being invited to a hearing by the local election commission, where the commission actually decides the major question for a candidate, whether to register a candidate to run for an office or refuse to register. And that's happened to us. Our candidate was not invited to this meeting, and the draft decision of the election commission was to refuse registration. And interesting that all the rest, there were 14 candidates, and all the other candidates were invited to this hearing. Only one candidate was ignored, and his representatives. So we brought this case to the district court, and during the district court litigation we realized that the problem is in the law, in the federal law on voting rights, which is, the provision of this law is so vague, it gives the power to the head of the election commission to actually decide who will be present at the hearing, and there's no criteria to make this decision. So basically, the head of the election commission can pick some candidates and invite them, and one can be ignored. So we brought, logically, we brought this case to the Constitutional Court of Russia, because the problem is in the law, not in the implementation. Again, it's interesting how when you conduct a strategic litigation, the victory per se in the court is not as important as sometimes the different outcome of the case can help to the broader audience. And in this case, our application was not accepted to be heard on the merits. Some technical legal issues, but the Constitutional Court did not ignore the major argument. The Constitutional Court went into analyzing, interpreting the provision of which we were complaining, and provided, as we say, a positive interpretation of this law. So this decision of the Constitutional Court will be published in a journal by the Constitutional Court, and its position is legally binding for the future elections to follow. And also, during these elections, we were sort of promoting one judgment of the European Court of Human Rights, particularly Anchugov and Gladkov versus Russia. This is a case about the right of prisoners to vote. I'm sure that in the US, felons completely prohibited to vote for the rest of their lives. But in Europe, the European Court of Human Rights is of the position that absolute prohibition in the legislation of the country of prisoners to vote, it's a violation of the European Convention, the right to vote. There should be some sort of criteria who of the prisoners can vote, and who cannot vote. So recently, I think in June 2013, the European Court of Human Rights delivered such a judgment against Russia. And before, UN Commission on Human Rights, 2 years before this, UN Commission also delivered such an opinion. So in our during this election campaign for the mayor of the city, we used this two judgments, opinions, and we sued the local election commission for not organizing polls at the prisons in the territory of Yekaterinburg. Of course, our goal was not actually to get this extra votes, but we wanted to spread this message. We wanted to make this decision of the European Court of Human Rights well known, and actually pose the question how this decision of the European Court is going to be implemented within Russia. There should be some sort of a federal law to make this judgment live. And now we also planning to organize a case before the Constitutional Court of Russia, where we will pose a question that when a person is convicted, is being sentenced to imprisonment, this person also should be aware that apart from being excluded from the public, being in prison, he also is losing the right to vote until he is released from the prison. And again, all the case materials are on the website. So I guess my point was we use strategic litigation to advance some issues, human rights issues we think are important, and our clients, the victims that turn to us, think are important. We help them to do this. And strategic litigation is important because non-governmental organization has very limited resources, and you can't really help everybody who turned for your assistance. So we try to select cases which might have big impact, not just for one person, but to an indefinite circle of people who can benefit from this or the other case in the future. And thank you very much for your attention.
We have time to take a bunch of questions, so I want to engage many of you in a discussion.
I'm curious whether you've seen any change over time in the political context around the law, and whether, obviously the Duma, the parliament, is passing laws without reading them. The president is invoking, whatever he needs to take Crimea, but what about the general educated population? Are they, Russians historically have been very skeptical about law. There are many proverbs about the last place you want to go is into the courts. Are you seeing people willing to use the courts to go work with you to try to change some of the law? Emily, do you want to ask people to introduce themselves when they speak?
Come up.
I'll try to respond to that one. If one mentions the sayings, probably the most pertinent one is that the harshness of laws is compensated by the lack of obligation really to follow them. And insofar as perceptions are concerned, I would say there is an enormous lack of trust in judiciary as it exists nowadays. It is proven by the number of applications to the European Court of Human Rights. Most of them are inadmissible because the applicants simply try to argue the same before the European Court of Human Rights, what they've tried without success domestically, and not every question raises the issue under the European Convention on Human Rights. Because they have not been heard domestically, they try to reiterate their arguments before the European Court of Human Rights. I would say this attitude, this lack of trust can be explained. And it's very hard to convince people really to go to courts when the courts failed them so many times before. And unlike Anton, I prefer not to apply to courts. I prefer to defend people when they are brought to courts. In this situation, I think it contributes more to the overall idea of need to change. We don't use these courts to change the system. We defend in courts to show that the system is flawed. Using the courts as a legitimate place to discuss flaws in the system. With the exception of the European Court of Human Rights, with the exception of the Constitutional Court of Russia, where you can discuss more generally and where you can probably apply with the idea to strategically change legislation, sometimes it really can lead to changes in legislation. But the most important point is lack of trust, lack of legitimacy, as understood by the recognition on the part of the people of the authority of existing institutions, courts included. That would be my point.
I've noticed that Russian people like to write letters to the president, as before they were writing letters to the Tsar. Unfortunately, that's the case. I recently was speaking just this morning with one of my clients her daughter died and her inner organs were actually taken away from the body without anybody's consent. And I asked what you have done so far. She said, I wrote a letter to the president. And there is no thought that there are courts to use. In general, I don't want to be very negative or to paint a dark picture. The general public is much more aware right now about the rights they have in the Russian Constitution and in the European Court of Human Rights. I have many examples to show where our clients, they are able to go to the court themselves. They just need an advice, and they try to use a Russian Constitution and the European Court of Human Rights, judgments of the European Court. The situation has changed a lot since Russia joined the European Convention. Courts started to use not just the text of the convention, but the judgments of the European Court, and which is very much unusual for the Russian courts, which is for the country which is a civil law country. The president is not a source of law, as generally understood. But the situation is changing. Unfortunately, the Russian authorities sort of adjusted to the criticism, particularly of the European Court of Human Rights. There were a lot of criticism of the Nadzor system, as the appeal of the judgment after it entered into force. A lot of criticism about the cassation system. And now we can see there is no Nadzor system, no cassation, at least it used to be. Now we have appeal. But when you go to the court, when you go to the appeal, you realize this appeal used to be a cassation. What changed is just the name. And the cassation, which is in existence right now, it is what used to be a Nadzor. So they changed the Vyviska, the title. And quite often, authorities involve the Council of Europe to justify the change. when recently in 2010 Civil Procedure Code received a new appeal, it also introduced a small provision which actually provide an immune from suing the government, the federal government in the Supreme Court. And this provision was sort of authorized indirectly by the Council of Europe, because Council of Europe provided 1,005,000 euros for the project on the appeal system, introducing appeal system in Russia. So there are a lot of work to do.
So I'm Valerie Sperling, Clark University. I have a question for both of you. So I'm somebody who went to school to study the Soviet Union, right? And in a lot of what you've said, I really hear echoes of the Soviet system. So for instance, the fact that the judiciary is not independent, right? It used to take orders from the party. The Communist Party would call up the judge and say, here's how to rule, this, what was called telephone justice. So there's that. And then things like the Electoral Commission, where it's the head of the Electoral Commission who basically decides on a patronage basis or on some other basis who gets to come to the meetings and who gets to be registered. These things sound Soviet to me, but the Soviet Union fell apart in 1991. And so it's been, and the Communist Party was deprived of its leading role in the Constitution in 1990. Sorry? Oh, you can hear it. I'm sorry. So anyway, my question is, the Soviet Union has been gone for over 20 years, yet the judiciary is still behaving as though it's operating in the Soviet Union. And so I guess what I want to know is, why is that? Is it the Soviet legacy, or is it something that's happened since then that makes these problems continue?
I would say yes, it's Soviet legacy. When you look at the Soviet examples and you compare the Soviet examples with contemporaneous situation, it gives answers to many questions. I've not been a lawyer during Soviet times, but I've read about it, and I think a lot of questions can be answered adequately by the reference to Soviet experience. In many other areas of life, like economical structures, a lot has changed. Very few institutional changes happened in the legal system. Yes, Council of Europe have had its say. European Court of Human Rights has rendered a lot of judgments that have allowed to change certain elements. However, structure in general, institutions in general, judiciary in general remain the same, minus ideology. And maybe current attempts to reinvent ideology is attempt to make this necessary step for the contemporary situation to really look like Soviet, because ideology is lacking. I think in the 90s, when there was much hope that changes are forthcoming, too much attention was devoted to the economical structures. Very few things have been really done insofar as judiciary, legal system are concerned. So I would say your estimation is correct, or your assessment is correct. Yes, that's very much predicated on the Soviet legacy.
It is yes and no. I wasn't a lawyer in the 90s as well, but I've read legal literature, and when I started practice law, I realized that what I'm doing right now with my colleagues, with the NGO, it was absolutely impossible to do even 10 years ago. It was not possible to go to the Supreme Court and challenge the regulation by the federal government. It was not possible to go to the Constitutional Court and challenge the law, a provision, and actually bring reform to the administrative justice. And now we can do it. But with the time, the blooming расцвет of this abilities, possibilities, were in the end of the 90s, the beginning of the 2000s. But now we can see that the legislation, the legal judicial practice is cutting it back. There's much more difficult now to reach the Supreme Court, especially if you sue the federal government or federal ministry. There are many small legal tricks that can be used by the judges, and you won't be able to reach to pursue the court to hear your case on the merits. That's the answer.
My name is Yekaterinburg. I'm a second year student in global government and human security, and I'm also from the eastern part of Ukraine, which is maybe not as much aligned with your presentation, but I have questions about the situation, and I was a little bit surprised by the fact that so people in Russian Federation went to streets to protest against the decision of Russian government to intervene into Ukrainian national affairs. And my question is it because of the lack of freedom of press, or is it because of limitations on rights to protest? What would be your state's explanation of that? And my second question is probably more to Anton, to second presenter. You were talking about litigation and using participation in political process as a method to go to a court. And I know that the human rights movement sometimes there are debates whether human rights activists should go to politics. There are some issues with this. So I'm wondering whether you use it as a tool to bring changes to the situation with rule of law, or you really want to get into politics in order to change the system from inside?
I have to отвечу.
I should say I was not surprised to see a few people protesting on the streets. For the reasons of context, of, I would say, public dissatisfaction with the results of those protests. As you probably know, in 2012, right after the so-called elections that led to the return into power of current president, there were a number of powerful public protests, both in Moscow and other cities. And they led to criminal prosecution of several people involved who have just been convicted and sent to medium terms, but nevertheless to jail. In many other instances, those who participate in public protests have been prosecuted for misdemeanors or for minor crimes, and that led to definite chilling effect upon the exercise of right to peaceful protest. One, of course, can blame or try to justify this behavior, but the attitude, the response to that is passive attitude and lack of desire to publicly protest because it can lead to consequences. That's, I would say I was not surprised. However, that does not, that does not reflect the opinions. Opinions may be more nuanced insofar as attitude to what is happening now in Ukraine is concerned.
And I will answer to the second question. When we first participated in elections, it was the initiative of the people who approached us for the legal advice. And of course, and we, as I mentioned, we decided to go to the elections for two reasons. First of all, to honor the trust of the people that turned to us, and the second of all, to continue our work, the litigation work, changing the practice, the law, if it violates human rights. And somewhere on the back of our minds, of course, we hoped to win the elections and participate in legislation work in this time, but maybe at the local level. Unfortunately, it's not that easy to win elections, even at the local level. For example, in 2000, first elections that we participated in, we were very close. Our candidate actually got the most of the votes. But back then, there was a provision which, a possibility for people to vote against everybody. And the results of the elections was cancelled because there were more votes against everybody. And this vote against everybody was very often used by those in power to spoil elections, to drop extra ballots to the box for the candidate called against everybody. And now, later, this provision was cancelled because it was more comfortable for the running party, and now they're returning it back. Unfortunately, the legislation is changing not steadily, but still, there are very many examples where active people win elections at the local level. Thank you.
My name is and if I understood you correctly, both speakers, there was a moment of hope in the 1990s, early 1990s, that the Russian system would open up a new role kind of phase. But it sounds to me as though the prospects are somewhat weaker now, somewhat like a river. And I guess I wanted to find out from each of you what motivates and what keeps you going, and what do you predict might be the situation in the next 5 years with respect to
there is a hope all the time. In the end of the 90s, there was one type of hope. Now there is a different one. In the 90s, I was so much excited that you, as a lawyer, with the support of your colleagues, of your clients, you can actually bring a change to the legislation of the whole country, of the humongous territory and population. Just your lawsuit. Now, yes, it's more difficult, but since then, we received a new legal tool called the European Court of Human Rights. And when reading this book by Peter Irons, I thought, this court is very similar to what is the US Supreme Court. Yes, there are many issues about how you are going to implement a judgment by the European Court of Human Rights, but that's hope. It's you still have this legal tool to deal with. Maybe Sergey can predict the future for the next 5 years.
I would try to tackle this from the wider perspective, not only from the point of view of boards. I think in the 90s, changes were happening from above. The government was willing to restructure the state machinery, and it looked more into economic reforms. It looked less at the structural changes insofar as judiciary is concerned. And there was a lack of public understanding that judiciary is in dire need of change. Because people wanted to be fair. Now, after these, I would see several steps that have been made back, several steps back. What gives me hope is greater public awareness that changes are needed in structural areas such as judiciary. So I think changes in the future will be driven from below rather than from above. It will take time. It will require new methods of change, not just public protests, and public protests are dangerous. But what I call public demand in justice, justice in wider understanding, not simply right to go into court, but also right to prevail in court when you have just cause, and right to have this positive judgment implemented and changes really happen, will be driven from below, will be driven by the public perception of the necessity to change, as is happening in Ukraine right now. But my short-term prediction or midterm prediction is very cautious. I will say changes will not happen in 5 years' time. They will happen further afield. It also depends on the weather question.
Thank you. And then
I have one question for each of our speakers. For our first speaker, I was wondering, considering the border law for the rights of people of Russia, and then for our second speaker, I had a question concerning the elections, the process. Is it like the United States where it's a direct election or not direct election, there's a electoral college, or is it different?
Frankly, I didn't quite catch the question on freedom to or freedom from generally, or in respect of something specific? Yeah. So you can always say that, why are you talking about those human rights? Let's speak about obligations. Most of human rights also imply obligations on the part of others vis-a-vis the right holder. Right to life means obligation of others not to kill. And of course, there were a lot of attempts to portray human rights as arbitrariness on the part of right holders. So one can say, human rights are so oriented on the individual that wider interests of society tend to be forgotten. And that's part of human rights rhetorics to explain that human rights are not unlimited. However, limitations upon human rights depend upon the type of right. For example, right not to be tortured is absolute, unlike right to freedom of expression. And those limitations, even for those rights that can be limited, are subject to very strict conditions. Conditions flowing from the rule of law concepts are one of the most important conditions for limitations of rights. For example, any limitation should be based on publicly promulgated equally enforced and independently adjudicated legislation. So I would say it's freedom to, but it's also freedom from, and those are just two sides of the same coin.
And yes, just a short answer. Yes, it's always direct elections, and in this regard, we are more democratic. There used to be a lot of possibilities to run a referendum. Many parties and individuals actually were abusing this right because they would organize referendum just to promote an agenda of the party or a particular candidate for the future election. Unfortunately, right now, the possibility to run referendum was so much narrowed down, so it's almost impossible to organize it.
Wait, up here first, please.
Hello, my name is Ashish. I'm a student at Matt Blossom. So, since you mentioned, public awareness is very important to your cause, how has social media affected your organization in terms of has it been helpful or even worse? That's it.
Social media definitely contributed to speeding up the things. So in order to realize something now, you need fewer time, because you can't just say you don't know. That means changes are very fast. You can have very general perception you should go to the streets and take part in demonstrations in 2012, and you will have apathy in 2014. So no one knows what will happen in 2016 or 2018. So I would say contribution of social media means that you have another speed of awareness and of changes in the mindsets. Whether it's for good or for bad, I don't know. I think it's just part of the 21st century. Shall I answer that?
Sure.
When maybe before 2002, I remember we would distribute press releases on particularly court hearing or the results of the hearing, and we will receive instant phone calls from the media asking questions, or we would have very good attendance of our press conferences. As later on, the media wanted to write mostly about consumers' rights protection. The rest, it was kind of prohibited, or I don't know why, but well, I can guess. But the attention of the media was very much lowered down. And now the internet, the website of the organization, social media is actually the only tool that NGOs have to distribute the message across the population.
In the United States, I certainly am very concerned about the Supreme Court and changes in the Supreme Court. Could you comment a little bit? I can imply from what you're saying that there has been little change in the Supreme Court, but could you comment a little bit about the membership of the Supreme Court from the 1990s forwards, if there's any, how the membership has withstood? I'm assuming the outlook isn't too good, but maybe comment a little bit about the membership of the Supreme Court and changes from the 1990s on.
Who is that?
I think it's enough to say that the president of the Supreme Court used to be a judge of the Moscow City Court in the Soviet times and used to pass sentences for those convicted of anti-Soviet propaganda, including Orthodox priests, who are now, of course, someone who are in favor. And that's public knowledge. So I would say, I would not associate myself with Anton's hope that Supreme Court or access to Supreme Court will change things with, for example, governmental regulations. It's great to have a right to sue the government in the Supreme Court, but it's better to have another Supreme Court first. It's definitely Soviet career path for judges who are members of the Supreme Court, and many of them, including the President of the Supreme Court, are just back in 80s in terms of their backgrounds.
I think, Sergei, you misinterpret my attitude towards the Supreme Court. Yes, the biggest concern is the age and the education of those in the Supreme Court. And it's not only the feature of the Supreme Court. The region I'm coming from has its regional court, Sverdlovsk Oblast Court, and the head of this court was since 1988, I think, when Lebedev, the head of the Supreme Court, was the head of this court since 1986, almost the same age. But Lebedev is still in power. Our chair of the regional court recently was changed. I think it's important to stress that the members of the Constitutional Court are mostly from professors from different law schools, and judges of the Supreme Court are judges who rose from district courts, regional courts, up to the level of the Supreme Court. So I guess those who are at the Supreme Court has more freedom to argue their cases, their judgments.
One last question.
My name is Alex. This is a question for Sergey mostly, but I'd love to hear your speech. The judicial system in America has the 3 separate branches, and as I'm sure you know, that's in order to try to prevent corruption of power in one particular branch. And Sergey, you mentioned that the clerks make their way up to the judges, and they are used to taking orders when they're clerks, so then therefore when they're judges, they're still used to taking orders. And I was just wondering, from whom do those orders come? And who do they have to kind of obey?
It's easy from more senior judges. And there was a recent example of interesting arbitrary application of law when one of the opposition leaders was convicted. Mr. Navalny was convicted, and then he was released on the following day, actually, without his appeal having been determined, pending appeal. That was something unheard of before, that someone convicted and sentenced to jail in first instance can be released on the following day, pending appeal. And there is an interesting joke about that at some echelon in the higher judiciary, the messages were mistaken, and first message was wrong, and then another message made its way back to the district court. In Greenpeace case, there was an interesting point when the people were about to be bailed in St. Petersburg. The very first case, time-wise that has been decided. In that case, bail was denied, extension of detention was ruled, and the second case, which was heard 2 hours after the first case, was intervened or was stopped just before the delivery of the judgment. The judge disappeared, probably received a phone call, came back, and decision was different. So it's normally, I would say, taking orders from the more senior judges, who in their in their turn can receive mixed signals from above, and sometimes it can lead to chaos on the lower level. But important problem, I would say, is judges considering themselves to be a part of vertically oriented hierarchy, like in corporation, unfortunately.
Well, we have some wonderful refreshments over here, and I'm sure both speakers would be happy to engage with anyone who has further questions over refreshments. Thank you very much for coming.